Good afternoon, everyone. My name is Jeremy Herman. I am an employment lawyer at Samfiru Tumarkin LLP. I'm located in Toronto, Ontario. It's great to be back with you. I've done many of these Q&A sessions. As you know, we do these Q&A sessions multiple times a week across all of our offices. We have offices in Toronto and Ottawa, in Ontario, and also in Vancouver, British Columbia, and Calgary, Alberta. And the goal of today is to get as many employment law questions answered live. So please don't be shy. Ask your questions. I'm here to answer them live. You have access to an employment lawyer for half an hour. So please ask your questions, and I'd be happy to answer them. Before we get started with your questions, I'm going to talk about a very hot topic right now. As I normally do, I like to start off these sessions with something that is very current, happening within the world of employment law. And so what we're going to talk about is that Ontario is moving to ban unpaid restaurant trial shifts. So what that means is that currently when you work at a restaurant, you get paid for the time that you work. But it isn't currently illegal to not pay workers who are trying out for the job, right? Workers who are on a trial shift. And so Ontario is looking to pass legislation that would become part of our Employment Standards Act in Ontario, part of the legislation in Ontario, to ban that. So employers, restaurant owners will be obligated to provide pay for the workers who are on trial. Also, the legislation is looking to prevent restaurant owners, employers, to deduct wages for situations of dine and dash or gas and dash. So when a customer might come in and eat, but then leave and not pay for their food, which is stealing. Right now, it could be that the employee takes the hit, and that would be banned under this new legislation. Additionally, as we know, it's very common currently in the hospitality sector for employees to receive tips as a pool. And this new legislation is attempting to pass law that would require employers to advise employees if there is a pooled tips situation. And so that can't come as a surprise. So those are a few new updates that are coming, hopefully, as part of the Ontario Employment Standards Act. One last thing that I should mention is that employers will be mandated to allow employees to choose the deposit account for direct deposit tips. So employees will have that choice. Again, very important updates within the world of employment law. It's brand new, and it probably impacts many, many people out there, hopefully many of our viewers. So stay tuned. We're going to be on top of this new legislation, and we'll provide you with updates as we receive them. Okay, so that's it for our hot topic to start off the Q&A session. Let us move into questions. I have a bunch of questions rolling in, which I'm always very pleased to see. So let us begin with a question on Facebook from Tanya. Can my employer cut my hours in retaliation for needing to take a sick leave? Absolutely not. That is illegal completely. There's a lot of things that are illegal about that. So first of all, your employer cannot cut your hours in general. That is something that we call a constructive dismissal. And so let's break that apart. Let's figure out what is a constructive dismissal. Important that you have an understanding of what that means. We've talked about it many times, but it's a very common issue. And so let's talk about it again. So a constructive dismissal is a situation where your employer is implementing significant changes to the terms of your employment that you do not agree with. For example, your employer is cutting your pay or cutting your hours or changing your job location or changing your duties. There's different examples of a constructive dismissal. or your employer has condoned or created a work atmosphere that is toxic. That could also be a situation of a constructive dismissal. In that case, you are entitled to your full severance. You can treat those changes, so long as you don't agree to them, as a termination of your employment, and you can seek your full severance pay. Important though, a key piece is that you don't agree to the change. So we deal with situations all the time. I've had it come across my desk many, many times where employees have condoned or accepted a change to the terms of their employment, but then they realize they don't like it, and so they seek employment, legal advice, but often it's too late at that point. So for example, Tanya, if your employer cuts your hours and you do nothing about it, you let it go for a couple months and you don't challenge it, well, then you've condoned it in all likelihood. And it would be challenging for you at that point to come along and say, I don't like this anymore. I'm treating it as a termination of my employment. Additionally, you could accept these kinds of changes by way of your employment agreement. So it's not uncommon for employment agreements to say that the employer has the right to implement significant changes to the terms of your employment, or changes to the terms of your employment, whether they're significant or not. And you are agreeing to that by signing this employment agreement. So if you do that, that is accepting changes that might happen in the future. So very, very important when you're about to sign an employment agreement, look out for a clause like that. And if it's hard for you to find, it's important for you to seek legal advice, right? Contact us at help@employmentlawyer.ca so we can advise you on whether there's a clause in your employment agreement that permits the employer to implement changes to your employment. Because if that is a clause in your agreement and you sign that agreement, it's going to be that much more difficult, if not impossible, for you to challenge effectively any changes that your employer may implement in the future. So that's one element. So Tanya, cutting your hours is a constructive dismissal. You should absolutely challenge that with our help. If it's in retaliation for you seeking a leave, a sick leave, that is another separate issue. That is called a reprisal, or in other words, retaliation. Your employer cannot retaliate against you for simply seeking something that is your right. So if you require a sick leave, if that's medically documented, your doctor has advised that you need a sick leave, you present that to your employer and your employer doesn't like it, and then they cut your hours, that is absolutely retaliation, and that is illegal. And so do not accept things like that. It could even be a breach of the employer's duty to accommodate you under the Human Rights Code in Ontario. So under our human rights laws, employers have to accommodate their employees. If an employee needs a sick leave, or an employee might need a certain accommodation in the workplace, an employer has to accommodate that. So a lot of issues with what's happening there, Tanya, and you should absolutely contact us and we can help you challenge these issues. Okay, let's move on to a question from Liz on YouTube. So Liz says, my boss doubled my workload without talking to me or giving any time to make the adjustment. Okay. And Liz says, I have a part-time minimum wage job, and I believe you're saying that your employer is accommodating a disability of yours. So this sounds certainly problematic, Liz. If you have a disability and your employer is supposed to be accommodating you, or they have been accommodating you, as I just talked about, and then your employer imposes significantly more work on you, which flies in the face of the accommodation, which means that the employer is supposed to be accommodating you, and then now you have more work to do, and that is hurtful to you and potentially what your restrictions are because of your disability, then that is a problem, again, under our human rights laws. So your employer has a duty to accommodate you, and they cannot just impose significantly more work on you if that makes the accommodation impossible. And Liz, you should definitely contact us, and we will help you with this If you have a follow-up question, please feel free to post it in the chat. Okay, let us deal with another question on YouTube from Myopia. Are non-solicit clauses in Ontario enforceable? My contract has 2 sections that outline a non-solicitation clause for the company. Are non-solicit agreements the same as non-compete? I work in manufacturing. To what extent would this apply? Okay, a lot packed in here. So let's unpack it. Non-compete agreements are typically illegal now. They weren't always, but they are now illegal over the past couple of years for most situations. Not every single situation. There are some individuals, some employees, very executive, high-level employees who might be legally able to be bound by a non-compete agreement. Non-solicitation agreements are different. They mean that essentially you cannot try to seek the clients or the employees of your former employer. Those are legal. They have to be done properly. They can't just say that you can't solicit forever. Usually there's a time frame set out, and that time frame has to be reasonable. But in general, non-solicit agreements are enforceable. The courts don't love them. They certainly don't like non-compete agreements. Now, non-compete agreements, like I said, are illegal anyway in most cases. But even historically, the courts did not like non-compete agreements because they don't want employees to be restricted. They want people to be able to find jobs within their experience and training within their industry. And non-compete agreements prevented that. Non-solicitation agreements, though, don't necessarily prevent you from not being able to find a job in the industry. If you work for one employer and resign or are terminated or laid off, and then you want to go work for another employer within the industry, you can do that even though you have a non-solicit. You just cannot go and solicit your previous employer's employees or clients. So that is really, in a nutshell, the difference between non-compete agreements and non-solicit agreements. So Myopia, I'd have to actually see your non-solicit agreement or clause. It could be enforceable, it may not be. Every case is different, but in general, they are legal non-solicit agreements, depending on whether they're done properly. So you can contact us at helpandemploymentlawyer.ca, as you see on the screen, and we can set up a consultation. I'd be happy to review your employment agreement. I do that all the time for clients, and advise on whether the non-solicit is done properly, whether it is actually enforceable and will restrict you going forward as you search for new work. Okay, let's move on. We have a question from D. Taylor on YouTube. If you sign a contract for 2 years, can the employer terminate your contract after 8 months? Good question. So if you sign a contract for 2 years, that's known as a fixed term contract. Okay. You are supposed to be working until the end of that period. So in this case, 2 years. Now, if your employer terminates you earlier, like you say, Taylor, after 8 months, then that is improper. It's a breach of contract, right? Because the contract says you should be employed with that employer for 2 years. And the employer would be responsible to pay you out until the end of the 2-year period, which is often very lucrative for people, for employees. So if you were supposed to work there for 2 years, that's what the contract says. But then the employer breaches it by saying bye-bye after 8 months. Well, now there is a year and 4 months left of the contract, right? 16 months left of the contract that the employer has to pay you out for. This is very common. I've dealt with this many times. It's called a breach of a fixed term contract. Definitely contact us, Taylor, and we will help you with that situation. You are likely owed significant compensation as a result of the employer breaching this fixed term contract. Okay. let's move on. We have a question on YouTube from Anna. I've been injured at work, and my employer is not convinced that I was injured at work. Okay, well, usually if you're injured at work, that is going to be within the world of WSIB. And so you would potentially be entitled to WSIB benefits, potentially loss of earning benefits if you are actually unable to work and you need compensation in order to get you by. Then you would be potentially entitled to those loss of earning benefits. There is a procedure in order to prove that you were injured at work, but this is something that WSIB takes care of. So I definitely urge you to seek their assistance. Okay, moving on. Let's see, we have a follow-up from Liz. So Liz says she went to HR requesting help, and they don't agree that there's any problem. I can and would do the job I began and said so. Docs agreed doing the job without added workload. Okay, so Liz, I'm having a bit of trouble following what's going on here, but it sounds to me like there's some sort of dispute you're having with the company, with HR, about whether they are accommodating you properly or whether they're improperly providing you with enhanced workload. So definitely contact us about it. Let's set up a consultation and we can talk about this, whether it's improper. It sounds like it is improper, and we'll talk about what kind of recourse you have. Okay. Okay, let's move on. We have a question from DDV Baseball on YouTube. Can an employer use information from an exit interview against you? If you have resigned, should you decline participating in an exit interview? Good question. If an exit interview is part of the process, which in some cases it is, not always, you shouldn't decline. They shouldn't be using information against you. I'm not sure exactly what information you're referring to, but they shouldn't be talking badly about you or disparaging you in any way, nor should you of the employer. But in general, if it's part of the process, I wouldn't recommend that you decline an exit interview. But there is potentially recourse if you can prove that your employer has, or your previous employer has used information against you, something that might have come up during an exit interview. If they're sabotaging, for example, your ability to find a new job within the industry based on something that you discussed, that would be improper, potentially illegal. And so we should talk about it. So definitely contact us at helpanemploymentlawyer.ca. I also want to note, as you've seen on the screen multiple times, you should go to our website rather at employmentlawyer.ca, and there's tons of resources available on most of the topics that we discuss today. So check it out, employmentlawyer.ca. We have a wealth of information. So it's very helpful. It's free, anonymous. You can find out more information there. Okay, let's move on. Happy to see all the questions coming in. So we have one on YouTube. I recently got terminated after working for a company for almost 7 years. What should the severance package be in your opinion? Okay, this is a great question. So as you see on the screen, pocketemploymentlawyer.ca. That is an amazing tool. Part of the Pocket Employment Lawyer tool is what's called a severance pay calculator. We have provided on our website a severance pay calculator. It's free and anonymous. You can use it whether you've been terminated. You can use it whether you haven't been terminated, and you just are interested to know what your severance might be if you were ever to be terminated. It asks you very simple questions, and then it will spit out for you a range or an amount of severance that you would be entitled to. So I definitely recommend that everyone use that tool. My assessment would be that if you have been terminated after 7 years, if you're working for a certain kind of company that has a very large payroll of 2.5 million or more, then you would be entitled to at least 14 weeks of pay, okay, based on your 7 years. depending on the size of the employer. If it's a smaller employer, it might only be 7 weeks of pay minimally. But in all likelihood, you're entitled to much more than that. You could be entitled to anywhere between 7 and 12 months of pay. I need to know more factors, more circumstances about you. What's your age? What position? How much money were you earning in that position, etc. What kind of industry are you in? And that will dictate as well how much severance you're owed. But in all likelihood, it's in the 7, 8 to 12 month range. So definitely contact us. If your package is less than that, which it probably is, because employers don't usually offer the full amount that they're obligated to provide when they terminate an employee, contact us, use the Pocket Employment Lawyer tool, use the severance pay calculator, see what you're owed, and then contact us and we will help you get that compensation. It's not difficult at all for us to do so. Okay, I hope that helps. If you have a follow-up, you can post it in the chat. Let's move on. So we have a question on YouTube from Just. Regarding contract work, for example, the contract is for 12 months and it only lasts 7 months, but the contract states 12 months or before. If it ends before, am I owed anything if they put before in? So again, it sounds like a fixed term contract situation, but what might be unique here about this contract is that they said that they'll terminate you for your contract rather would end at 12 months or potentially before 12 months. I think that's what I'm understanding from your question. And that could still be problematic. It depends on how it's drafted. I need to see the entirety of the contract and then I could advise whether the employer owes you compensation till the end of the 12 months or whether they've done something that's legal by letting you go earlier. Okay, so let's arrange a consultation. Contact us at help@employmentlawyer.ca and we will discuss your matter. You can also contact me directly. We can have it put on the screen what my direct contact information is. Anna, do you have an office in Calgary? Yes, we do. Okay, let's move on. We have about 7 minutes left of this session. So we have a question on Facebook from Jeanette. I moved to remote work during the pandemic and in 2021 sold my house and moved. Okay. A new COO is now asking us to come in twice a week. I now live almost 3 hours away from the office. What options do I have now? Do I have any right to refuse or can this be forced? Great question. Generally speaking, if you always worked for a company in person and you went remote during the pandemic, as many employees did, and now the company is asking you to come back to work, generally speaking, the company can do that because it was a unique time during COVID. Many, like I said, many people worked remotely, and the default is that you don't work remotely, like how you never did work remotely before COVID-19. And so generally speaking, your employer would be within the right to ask you to come back to work. There are potentially options you have, though, to negotiate that. If you can effectively ask your employer and negotiate that you can work remotely, full-time or part-time, that certainly could be done. If you worked remotely prior to the pandemic, even some of the time, and then during the pandemic, it became a bit more permanent, and you continued working remotely even after COVID slowed down in the last year or so, then you might have some more recourse there. Why? Because you worked remotely before COVID. You might have worked a little bit more often remotely during COVID. And then your employer didn't even call you back to work for quite some time. They still permitted you to work remotely. Well, then we can potentially argue that that became a permanent term of your employment, that you were able to now work remotely, in which case it can be challenged and potentially as a constructive dismissal if your employer is forcing you back to work. There's no one answer fits all. So this is very circumstantial. It depends on the situation. It could potentially be a constructive dismissal. It may not be. Okay, so I hope that was helpful. It does apply this situation to many people. So if there's a follow-up, please post it in the chat. We have a follow-up from the individual who got terminated after 7 years. They need the package to be signed by next Monday. Do I have to sign it by then? They offer me 7 weeks of severance. Okay, so they're offering you the minimum amount, it sounds like. Definitely contact me. You see the information right on the screen. Use that QR code. You can contact me directly. I could probably help you with this. The deadline usually doesn't matter. It's usually just a pressure tactic in most cases, almost always. What that means is that most termination letters are going to have a deadline because the employer wants you to sign the agreement that they want you to sign. They don't want you to negotiate. So they're not going to give you 2 months, for example, to respond to the severance offer. They're going to give you a few days or a week because they want that pressure on you to sign the agreement that they offered you. They don't want you to negotiate. They don't want to have to pay you more severance than what they offered, in this case, 7 weeks. But the law imposes a real deadline of 2 years. You have 2 years to pursue your severance entitlements. After that point, in almost all cases, you will not be able to pursue it further. But certainly a few days or a week, that is a deadline made up by your employer. There's no legality assigned to that deadline. So don't worry about the deadline. Either way, though, you should act swiftly. It's important to always do that and try to negotiate this package as soon as possible. With our help, please contact us, contact me, or contact us at helpandemploymentlawyer.ca, and you and I can speak personally about this. Okay, let's see. Lisa asks on Facebook, I was just laid off due to financial difficulties despite being a senior employee. I was told I might be brought back next month, but they're unsure. Should I just wait this out? No, you should not wait that out. You haven't been terminated, you've been laid off, but you can treat that layoff as a termination. So the law in most cases allows you to say, I don't agree to this layoff. So long as your employment agreement doesn't allow it either, you can treat that layoff as a constructive dismissal. We've been talking about a constructive dismissal a bunch of times today. So again, a layoff is a significant change to the terms of your employment, right? You're no longer working for some time. So you can say, I don't agree, and I'm treating that as a termination, and I'm entitled to my severance that I would be entitled to had the employer terminated me. Okay, so long as your employment agreement does not permit these types of things, this type of layoff, and so long as you have not agreed to it either. So if you wrote, sometimes I've seen an employee write back to the employer saying, I understand, hopefully I'll be recalled back soon, something along those lines, that could be considered acceptance of the layoff, and then you might have some difficulty challenging it later on. But so long as you haven't done that, and so long as the employment agreement does not permit these layoffs, then you can treat it as a termination and seek your full severance pay. Okay, well, I hope that was helpful. It was a very good session, packed with questions. We dealt with many issues, and we are back tomorrow. Like I said, we do these many times a week. We're back tomorrow at 1 p.m. with my colleague Teelan. So make sure to tune in then, and I will be back with you soon. Take care, all the best.